Good afternoon, everyone. How are you doing? How are your cell phone batteries? Are they getting down to about 20%? Melinda and I are going to talk about preparing your client and yourself for third parties that may intersect your case. So family law clients generally will come into our offices dealing with a great amount of stress and often some of the worst days of their lives. They may have promotions, their feelings may be very raw, they may have recently cleared out bank accounts, they may not have seen their children for an extended period of time, they may have received a protective order in the mail that morning. They may themselves be the victim of domestic or family violence. Generally speaking, we see our clients in a significant state of personal crisis. So we see every day, and what many litigants really want to get out is their story. They want to tell how they've been off. And normally we'll see otherwise good, decent, normal people really on kind of their worst behaviors. And so it's important as an attorney to provide that medium for the client to kind of get it all out, not only from an information gathering standpoint, but also just for the pure cathartic nature of it. But one thing that I really think about is when that client that's really amped up or that's really highly emotional, when they leave my office and those doors shut and they go back out into the world, how are they going to interact with third parties? Now, for those of you who have seen the movie Swingers, you may know the story of Mike.
Hi, this is Nikki. Leave a message.
Hi, Nikki. This is Mike. I met you at the Dresden tonight. I just called to say that I had a great time, and you should call me tomorrow or in two days, whatever. Anyway, my number is 213-555-4679. Hi, Nikki, this is Mike again. I just called because it sounded like your machine might have cut me off before I finished leaving my number. Anyway, and also, sorry to call so late, but you were still at the Dresden when I left, so I knew I'd get your machine. Anyhow, my number is 21.
Hi, this is Nikki. Leave a message.
213-555-4679, that's it. Just want to leave my number. Anyway, I think that was weird and desperate. Just hang out and see where it goes, because it's nice and, no expectations. So, okay? Thanks a lot. Bye-bye. I just got out of a 6-year relationship, okay? That should help explain why I'm acting so weird. I just wanted you to know that. It's not you, it's me. I'm sorry. This is Mike. Hi, Nikki. This is Mike. Could you just call me when you get in? I'm going to be up for a while, and I'd just rather speak to you in person instead of trying to fit it all into...
Hi, this is Nikki. Leave a message.
Nikki and Mike. This just isn't working out. Maybe we should just take some time off from each other. It's not you, it's me. That's what I'm going through. All right. It's only been 6 months.
Mike?
Nikki, great. Did you just walk in, or were you listening all along?
Don't ever call me again.
Wow. I guess you're home.
Now we know that these sorts of calls are taking place by our clients, right? Maybe taking place right now while you're at this CLE. While an awkward call or to a girlfriend or a prospective dating client or anybody out there, that may not have a great effect on the case. But think about if your client's making a series of phone calls like that to the court staff. I've had it happen. It doesn't. What about if they're calling the custody evaluator's office to set up their appointment and they're making successive calls and really want to tell their story to the evaluator's legal assistant or to their assistant right then and there. Now, these are the sorts of things that your clients, when they're in this heightened state of emotion, may find themselves doing. And so, when your clients intersect with third parties who can affect their case, your role as the lawyer essentially is to advise them as to what to expect and to prepare in some instances and edit their responses. You can have a significant role in your client's success. So what we're going to talk about in this presentation. Third parties, they're everywhere. So who can make the most impact in your client's case when your client and yourself are interacting with them? Well, we have ADR third parties. We're talking about mediators, arbitrators, private judges. Custody third parties, so that can include guardian ad litems, child custody evaluation experts, parent coordinators. Valuation third parties, so appraisals, business valuation experts. And fourth is what I characterize as alimony third parties, so that could be a vocational rehabilitative expert. And so we're going to start talking first about ADR third parties, and Melinda's going to take over.
Thanks, Jason. Good afternoon, everyone. As Scott said, I'm from Ohio, so we're not really here today to talk about the law per se, but how to prepare your clients for these types of meetings with the mediators, the alternative dispute resolution team, guardian ad litems, custody evaluation, appraisers, all sorts of that. So in Missouri, is everybody, for the most part, from Missouri in here? Can we get a show of hands? So when it comes to Missouri, do you guys do mediation before you proceed with trial, after you're already in the trial stage, or at what point? Anybody? So before you even proceed to filing any complaints? After the complaint, but before any pre-trials or anything take place? So how do you prepare your clients for these trials? Or, excuse me, for these mediation processes? Do you select your mediators, or does the court select your mediator for you? Both. So when you're selecting your mediator, how do you know what the right mediator is for your client? So the first thought that I have is that you should know your client. Because if you don't know your client, you're not going to know how your client's going to jive with any of these third-party neutrals that they're going to have to deal with. So you should understand the client, how they process their information. Are they visual learners? Are they auditory learners? And whether the client is easily distracted. You should also work with that client's communication style, not against it. So when selecting a mediator, have your client participate in that process. One of the keys to the successful mediation is the selection of that right mediator. So you should choose that mediator carefully. I personally like to get a list of all the mediators before I choose one, see if the other side will agree with my list, and then narrow it down with my client's assistance. I always like my clients to be involved in these processes, that way they can't tell me at the end of the day that the mediator was against them because they didn't like them, because that client helped or your client helped pick out that mediator. I also, if I haven't used a mediator and the opposing side is set on one and the court's going to go with it, I also do your research. Talk to other attorneys around the area, see if they've used them before, and see what their recommendation is on them. Do they get along with your clients easy? What is their mediation style? Also, make sure that your client understands the process of mediation. Your client should work with you hand in hand in understanding that process and help you prepare for that. They should remember that mediators do not make the ultimate decision, it's the clients that make the decision. And some mediators may not even offer a recommendation. They're just going to kind of facilitate the process and hope that the clients can reach one based on the negotiations back and forth. Since mediation affects your clients directly, shouldn't they be involved in every process of it? Does everybody agree with that statement? How will your client know what a good mediation settlement is if they're not prepared and they don't know what they're trying to settle? So when you're preparing your client for mediation, you should also prepare them to know what the documents are that you're going to use in that mediation process. What documents do you think you're going to need to use in the mediation process? Financial statements, good. Anybody else? Parenting plan? What about any evaluations, whether it's an expert evaluation or a guardian ad litem evaluation? So what I like to do is when I'm preparing my client and preparing these exhibits, I like to do like a trial asset and liability spreadsheet, and then also insert a column in there for the exhibit that identifies that asset. Your client should also assist you in writing any type of a mediation brief or a mediation summary. We call them mediation outlines. And the reason being is that they're the ones that live the day-to-day life. They're the ones that actually know the facts and should be retrieving these facts and these documents for you. Mediation is not like a trial. And so therefore you're going to want your participants to be relaxed but remain businesslike. At the mediation session, they should remain cool and under control. If you let your client get out of hand or out of control, that mediation session is likely going to fail. Remember that mediation is a facilitated, business-like negotiation. And both parties should be seeking a good business deal at the end of the day. It's rarely personal, even though you are bringing these personal aspects of the case into the mediation, especially when you're talking about the custody for their children. So if they treat the mediation like a business deal, you're more likely to prevail because you're taking the emotion out. Should also keep the process informal. In formulating the ground rules with your client for this, the mediation session, you should strive for informality. And because when it's more legalistic, the session appears to be more nervous-like, and the participants are nervous. They really don't know what they want to do. So being well prepared can help with that anxiety that your clients may face. So when preparing, when you're going to go into the session, definitely know the facts. So I know you guys start the process out here early. So do you do all of your fact-finding prior to going into mediation? I see one head's shaking yes. Anybody else? So if you're not prepared, how are you going to know what a fair settlement is? You should be able to document every point made in the mediation session. Parties that go into mediation with nothing more than generalizations, vague stories, and unfounded accusations, or they just whine the entire time, the mediators don't want to hear you whine. The mediators there are to do a job and get it done. So ultimately, if you go in with that kind of mindset, you're going to invariably lose. Take time with your client to prepare and rehearse. Spend as much time and energy as necessary to put this game plan together for a good factual presentation so that it's clear, it's smooth, and it flows. If you don't do this with your client, you're going to bounce all over the place in mediation. The mediation can end up taking a longer time than what is necessary. Also, don't fall in love with your case. Don't let your client do that. You're going to want them to remain objective. The more time you spend preparing, the more convinced you're going to be about the outcome and that your outcome and what it is that you want is the right outcome. So you need to make sure that your client stays in check throughout this process. Picture a stoplight. You've got red, yellow, green. So red light means you're just not willing to settle on this. So mark out those guidelines. Do the green. What are the good ones? What's the best case scenario? And then someplace in the middle, like the yellow bracket. Okay, but not really what the client wants. So make sure you define what some realistic goals are with your client. In the course for preparing mediation, Define what that win is. What is it that the client ultimately wants? And you want to define this prior to the day of mediation. You don't want to go in there and not know what it is that your client ultimately wants or would consider a win. What is a good settlement? Make sure you talk with your client what a good settlement is. Should they look at the time of the cost and time spent on this, and is it worth it, or is it worth going to trial over if you don't hit these certain areas? So know where you want the mediation to start and end. So some of the critical documents that we talked about, financial statements, vocational evaluations, make sure that these are prepared and identified. Always bring extra documents to share with your other attorneys in the mediation, the mediator, and any other third party that may be there to help assist. I know sometimes in our mediation sessions we have parent coaches come in or a guardian ad litem. So just make sure that everybody's prepared. You're also going to want to bring in any legal support that you have. Do the attorneys here participate in the mediation, or do you just have clients participate in the mediation? Varies. That's the way it is in Ohio as well. So if there are legal issues, on my cases, I'll bring in any supporting case law or any new case law that's come out to be able to help support our position, whether it's for deviation in child support or the terms of spousal support. And those are just some examples. So have that case law and statutes available, and also any tracing documents that you might need for a separate property claim. A lot of times when I go into mediation sessions, I don't see the other side as prepared. I see them utilizing mediation just to try to way to settle the case and get the clients out the door. And so when you're prepared, and more prepared than your other side, one, it makes you look good in front of your client, and two, you can get a more favorable settlement that way because you actually know the facts and you have the documents to be able to back it up. So learn the strong points of your case. During preparation of your case, learn these strong points as well as the weak points. There are points that are clearly in your favor, are well documented, and cannot be argued or interpreted in any other fashion but to be favorable towards your client. Find these strong points, document them, figure out how to use them to leverage a favorable settlement for maybe a weaker point in your case. The weak points, though, are equally important to familiarize your client with, but are harder to do. It's really hard to get a client to realize that their case is weak in any certain area. These are the facts that will lead to the settlement in the other party's favor. You need not like these points, but you must be prepared to live and deal with them realistically and make sure that your client is as well. Be prepared to concede these weak points and try to minimize the damage that can happen to your client's case. And then also you're going to want to familiarize yourself and familiarize your client with the other side's strong and weak points. This is probably the most difficult task for your client to do. So you need to examine it from the other side's viewpoint. Find their strong points, learn how to deal with them, find their weak points, learn how to use them to your benefit, just like they're going to do with your strong and weak points. Remember that your objective in mediation is to convince the mediator that your case is stronger and more likely to prevail, and then let the mediator convince the other side of this. So to accomplish this, you must shoot holes in the other side's case and find the documents, point out any mistakes, inconsistent statements. Overinflated budgets is a good one. We do an affidavit of income and expenses. I'm sure you guys probably do some certain domestic relations affidavits that you have to outline. Find those holes. I mean, these are sworn affidavits. So if they're marking that their electric bill is $200 a month, but you have statements for the last 12 that average out to be $90 a month, this is an overinflated budget. So poke the holes in it when you can. They're pretty easy to find if you really look at them. The other thing is some attorneys like to, double dip. They'll put it in one column and put it in another. So just be prepared, and if you have your exhibits, your case is going to be stronger compared to the other side's just stating that there's something out there that's really not there. So also know when to walk away. Know what your terms for settlement are. Mediation a lot of times focuses on dollars and the custody aspect. So you must go into mediation knowing what your real top line is and your real bottom line is. And also know what the know your failure costs. You can establish your walkaway number. Your walkaway number is the number beyond which it is probably better to go back to legal action, as your costs are likely to be lower if the mediation session just ends up bringing new issues to light that you didn't know about. Also, you're going to want to make sure that you maintain control of your client and your client maintains control of their emotions. It can be a very lengthy and stressful process, even though it's supposed to be informal. And as you guys have been here already probably for 6-7 hours, it's a long day. Clients aren't used to this. And so then they start to get aggressive. And these aggressive, inflammatory tactics probably won't work best in mediation. You need to avoid getting angry, or your client needs to avoid getting angry or emotional. And focus on what's important and how to get the case resolved. When the mediator starts telling your client how weak their case is and starts throwing out outrageous numbers or settlement terms, make sure your client doesn't panic. Make sure that they know that this is just a tactic. This tactic is the mediator's doing this to the other side too, and this is how they get the mediation and the talks going on what should truly be a settlement. And then lastly, before you end your mediation session, if you guys have that good walkaway number or that good walkaway custody agreement, make sure that you at least outline and sign the terms of it. We don't like to leave our mediation sessions without drafting agreements. However, usually time does not allow for it. So we want to make sure that we have a good understanding of what the terms were so that nobody can go back in the future and flip and say, well, I didn't agree to that. So all in all, you should create some realistic expectations for your client. Make sure that they understand them as well. If they understand them, they're going to be able to help make the best decision for their case. And ultimately, it is their decision. So it can't come back on you. I mean, you've, from the start, had your client help you pick the mediator. You prepared them. They gave you the factual documents. If they're slacking on their end, you've got to pick up where they slacked. But at the end of the day, if they did not provide you a piece of information that the other side has, it makes your case look bad. So that's weak. Make sure they know that and make sure that it's going to come back to haunt them in the end. If the client is likely not going to be able to make a decision, consider scheduling another day of mediation if they're a type of client that needs to sleep on something before they settle, and stop the mediation early before all of the points are resolved so that the other side doesn't see that that's just your strategy for that. So that's all I'm going to have on mediation right now, and Jason's going to come up and talk about the custody evaluations and the guardian ad litem.
Okay, so by show of hands, who in the audience, what percentage of our audience practices routinely in child custody litigation? Okay, about 20%, 30% of the audience. Familiarity with the idea of a child custody evaluation. Who all, by show of hands, have participated in a child custody evaluation as counsel? All right. A little personal narrative about myself. Before I went to law school, I really fancied myself a thespian. I really wanted to go be an actor one day. And that dream kind of turned into a dream to be a director. And so I've had a chance to do a few of these continuing educations. And whenever I have a captive audience, I really try to scratch that inner director itch. And so what I've done is I prepared a one-act play in which I'm going to have some folks from the audience come out and act out an appropriate case for a child custody evaluation. So by show of hands, anyone like to volunteer? Okay, I'll take some people. Can you hear me? Can you hear me? Okay, this play is called The Litigants. Any willing volunteers before I pick anybody out of the audience? I have a volunteer back here. What's your name? Brandy? Yes. Okay, Brandy, come on up. I need a divorcing husband. An angry divorcing husband. Okay, come on up. We have Brandy. And sir, what's your name?
Mark.
Mark? That's okay. Here you go. Oh, there you go.
You do okay.
Okay. So Brandy and Mark, let's hear it for Brandy and Mark, everyone. Action.
We should probably talk about how we are going to divide the custody of our child.
Well, Since we are divorcing, I was thinking that I could just take the kids and move to Idaho to be closer to my parents.
Okay, but your parents live in Florida, and if you did that, then when would I get a chance to see them?
You wouldn't. But what is important is that I resent you and your years of emotional abuse. So I'm going to take the case from you, the only father that they've ever known, forever. This is fair because my feelings are hurt.
What are you talking about, emotional abuse? I never emotionally abused you. What does that have to do with the kids? I am a good father.
If you are such a good father, then why do you emotionally abuse me? You are emotionally abusing me right now. I'm going to go get a restraining order.
But the kids, they've lived their whole lives. Wait, but the kids have lived here their whole lives.
If I am happy, the kids will be happy too. Besides, they don't want to see you anymore. They told me so.
What are you talking about? Why are you even talking to them about this? What did you say?
I just explained to them the truth, that daddy is mean to mommy. I asked them if they wanted to love a daddy that is mean to mommy, and they said no. So we're moving to Idaho.
This is ridiculous. Where are they now? I want to speak with them.
Well, they don't want to speak to you. I'm going to respect their wishes. If you really love them, you'll respect their wishes too.
Did you stop taking your crazy pills? I just saw them this morning. I dropped them off at school.
And I suppose this is what makes you Dad of the Year. Maybe if you had paid more attention to us than spending all of your time working, you would have seen this coming.
Enough with the passive-aggressive crap. I had to work to make ends meet. If you would go out drinking with your, if you wouldn't probably go out drinking with your girlfriends at night, come home at 3 and get up at noon, the only reason you get up at noon is so you don't misjudge Judy.
Oh, right. Out with my girlfriends? You mean like Trisha?
Don't do this again.
Yeah, Trisha. You're always asking about Trisha. How is your friend Trisha? Well, now you can have her all to yourself.
Look, you just tell me where the kids are.
Oh, I bet you'd like that.
Of course I would. That's what I just said.
I'm done with this conversation and I'm done with you. You can talk to my lawyer.
Okay, fine. Who's your lawyer?
I'm not telling you. By the way, I drained our bank account, so don't think there's anything left over for you to get a lawyer. I'm going to get all the money and you're going to pay me for child support and alimony.
With the drained bank account? Perfect.
It will be once you are out of the picture. That's what my parents said. By the way, when I said they liked you, they really didn't. They never liked you.
They don't even know me. They don't even know me to not like me.
Yes, but I've been telling them all about the emotional abuse. You don't deserve me.
This is one thing we can all agree on.
Look, they can even hug and make up, so there's hope for us all. So that was kind of a silly example of what you may see, but I mean, if you think about it, if you do enough child custody litigation, you see a lot of parts of that exchange. And you know, that's an example of what really would be right for a child custody evaluation. And so when you're meeting with clients, it may be apparent in the first meeting that the case does call for a child custody evaluation or a guardian ad litem investigation or report. And so making that determination, that's something that you really should be discussing, very early on in the case, if it makes sense. Along with the concept of parent coordination for really acrimonious divorces. That very often you'll see parent coordinators involved in a case subsequent to the trial, subsequent to the sets of orders. So for those of you who are not familiar with those concepts, guardian ad litems and custody evaluation investigations are tools which can help parties with extremely divergent ideas for best interest of their children and custody arrangements. And one of the greatest potential benefits of these processes is that it can allow kind of the minute details of the case to be considered by a trained professional, and for a greater deal of informed analysis to be provided to the judge that would otherwise be limited by just the general limitations of court time and the judge's availability. One main benefit of either of these processes is that it tends to be the least harmful way to provide the court with information concerning the thoughts and wishes of the children. Likewise, other than parading in 5, 10, maybe 15 collateral witnesses into court and delaying the resolution of your case or angering the judge, a lot of this collateral witness testimony can be condensed and summarized by the evaluating non-party. Of the many differences between a custody evaluation and a guardian ad litem investigation, the most apparent would be training. Typically, a guardian ad litem is going to be an attorney or a social worker that has some focused training in areas like child development, child custody laws, and co-parenting, but they may lack a specialized scientific training. A child custody evaluator will typically be a licensed psychologist, sometimes a psychiatrist, but typically a psychologist. The parent coordination process is a tool that can help bridge the gap between the law and the emotions. Think of a parent coordinator as a referee or a mini judge. I call them the mini judge. It's a process that tends to be useful for a couple of main reasons. One would be to deal with kind of smaller issues that the client may not want to go to court over. We're talking about one parent is routinely 15 minutes late to parent time exchanges. One parent refuses to wash clothing at the conclusion of parent time. A client may not want to make a large investment in litigating that specific issue, but with the parent coordinator involved, they may be able to make binding recommendations that have a little more staying power and it can offer a swift resolution to some of these issues before they get out of hand. On the flash drive that was provided to each of you, we're not going to go into a lot of these forms, but I thought it was important. One of the big takeaways that I had from most continuing educations is really what are the forms that are provided to you. And so we've included, and some of my colleagues from the Illinois and Missouri offices were kind enough to supply some of this to me. We've provided statutory authority for custody evaluations in Illinois and Missouri. There's a proposed order for custody evaluation, which was drafted by Judge Beach of the St. Louis County Courts. We've included a PDF that has standards for guardian ad litems in the state of Missouri. We have a draft order appointing parent coordinators in Missouri as well. And then finally, there's two sets of guidelines that I think are really important. We're not going to really talk about them much today at all, but they're sets of guidelines for conducting forensic child custody evaluations. One's published by the American Psychological Association in 2010, and the other is published by the AFCC, the Association of Family and Conciliation Courts, in 2006. Those two guidelines specifically, if you ever are dealing with any sort of litigation after a custody evaluation has been entered, I always go to those as a resource for either bolstering the evaluator's testimony that would be offered at trial, or to find areas to poke holes in the report. So if those guidelines are not being followed, that's really where effective cross-examination and sometimes direct examination can be drawn from. So we're going to talk about education of the client before seeking out the appointment. In any family law case involving children, both the custody evaluation and the parent coordinator should be offered as tools or resources in the litigation process. A client should be offered all options with appropriate pros and cons of each. The one first and foremost thing that I would suggest anytime you're talking about a child custody evaluation is to be clear with the client that just because we're retaining and engaging the services of a child custody expert doesn't mean that you're going to get a favorable report. I think a lot of clients come in with the preconceived notion that if they hire an expert, that's going to be their hired gun and it's going to go their way 100% of the time. And that just simply isn't the case. Sometimes a custody evaluation is not the best suited process. I find that custody evaluations are most useful when we have indicia of mental health, when we have the client saying, look, my spouse is crazy, she's crazy, or he's crazy, they do all these inappropriate things. Well, when the judge needs to make that finding in the best interest factors of mental and physical health, how better to have that sort of evidence populated but by a licensed mental health expert. a thing to consider is that if your case has any weaknesses that are glaring from the onset, if your client is exhibiting signs of pathology, that although you're not a psychologist, you know, my client's crazy. Maybe pursuing a forensic child custody evaluation in which that crazy person's interests are going to be reviewed by a trained mental health expert, maybe that's not the best idea for your case. It's probably going to shine a light on some of the weaknesses of your case. Before deciding on whether or not to pursue a custody evaluation, you should always talk about expense. Sometimes that can be the deciding factor on whether or not you pursue the evaluation or regarding an ad litem investigation, because there's going to be a significant expense difference between the two. In Indiana, I find that they tend to be at a minimum 5 to 10 grand, and sometimes more. Generally, a custody evaluation will follow several procedures, each of which, if your client's acting like Mikey, can be perilous for your client to navigate alone. First off, anytime that a evaluator is engaged, the first thing they're going to do is be tasked with reviewing and familiarizing themselves with your existing sets of legal orders. They're going to want to figure out why it is that they've been sought out and what it is that the court or the parties are seeking analysis concerning. The parties are then provided informed consent forms by the evaluator and may be asked to prepare a biography, a personal narrative, a background of the case from their perspective, and any other information about the children and a list of collateral contacts. The third part of the process would be that the parties set appointment times for each to be evaluated with the children. Additional appointment times may be set for new spouses or third parties in the case, and payment will typically be collected at the time that the appointment is made. When evaluation day comes, the evaluation will typically be conducted with each parent and any cohabitating partner. And if they haven't done so already, the parties will typically submit any documents, any additional information that they believe is relevant, and they'll sign releases for things like medical records, teacher consent forms, and counseling records. Evaluation day itself will typically run at a minimum from a half day to sometimes a full day, sometimes more. And it's typically going to be in the evaluator's office. And it'll have one of the following components, typically all the following components. One will be a standard clinical interview with the evaluating professional. Typically, you will see a battery of psychological, IQ, and personality tests that are going to be administered. Typically, there will be observed interactions of each parent with the children, typically involving a structured cooperative task or a game. Again, cohabitating partners are typically going to be administered a standard clinical interview as well, and some forms of personality testing. Generally, if the child is verbally and developmentally competent to offer relevant and reliable data, let's think about 6-year-olds and up, the children may be administered a clinical interview or may be given some forms of personality or IQ testing. Following evaluation day, the custody evaluator will look at both parties' list of collateral witnesses, typically reach out to each of those witnesses and take notes. Once all the data has been collected and the testing is scored, a report will be compiled that's going to summarize the findings and will propose specific recommendations for custody, parenting time, and any other issues that would impact the psychological well-being of the children. The report's then released to counsel and sometimes to the court, typically under seal. Most counsel that I interact with, or most of my colleagues, think, okay, well, once the evaluation's entered, that's it, it's done. Well, what I've learned in discussing a lot of evaluations with issuing evaluation experts is that it's not done. Once the report's issued, it's still a living, breathing document. It can still be revised, it can still be edited, it can still be amended. And a lot of times, if I have a client who has received a custody evaluation that something just doesn't add up in it, I'll take the time to call the evaluator and have a discussion with them, or I'll set up a follow-up appointment with my client, and that can certainly lead to the possibility of an amended report or amended findings. Perhaps the evaluator misunderstood some component of the case, and so always keep that as an opportunity to, once it's published, that doesn't mean it's a done deal. Prior to the presentation today, I surveyed a number of psychologists that I've previously worked with in conducting custody evaluations. And I asked for some responses from their perspective as what do they see that counsel and that clients are doing wrong when entering into a child custody evaluation process. And the overwhelming response that I got was that most litigants enter their office with really no clue as to why they're meeting with the evaluator. They know that they're getting divorced, they know that they're involved in a custody action, but they really don't have any understanding as to what the process is and really who this person is that they're interacting with. Most responded that litigants enter their office confused as to the role of the evaluator. You know, many litigants, this is their first time being involved with the legal system at all, and many have never been involved with any aspect of the mental health system. If you think about what's the classical observation of a psychologist, it's someone who you go to their office, you sit on their couch, and you spill out your feelings for an hour. Well, that's not what a custody evaluation is. That's clinical psychology. In a custody evaluation, it's forensic psychology, and there's a big difference there. How I try to explain that difference to a client, and what tends to make sense is I kind of ask them to put themselves in the situation of they're accused of murder, and they've pled not guilty by reason of insanity. Think of that evaluator as the person who is assessing if you are or are not guilty by reason of insanity. That's the role of the forensic evaluation. It's not to be a shoulder for you to cry on. Quite the opposite. They're there to provide analysis to the court and not be your therapist. The second focal point of responding psychologists was that documentary information provided to the psychologist was made in an unorganized and incoherent fashion. Of any of the ways that you could fail your client, this to me is the most avoidable. We're creatures of organization. And so I would suggest that you insist that your clients collaborate with you as to anything that's going to go to the evaluator's office, you need to get a set of eyes on it first. Starting with the autobiography. If you've ever had a client go through this process, they will typically submit a written narrative of some sort. And if you look at some of these autobiographies, they need a lot of editing, not just from a grammatical standpoint, but from what is the story that this person's conveying. And in a lot of ways, it can have a very detrimental effect to their case if it's not edited. If I have a client that I run into that situation of, look, we have your autobiography here, but the story that you're trying to weave is not what this evaluator is going to want to hear. If I have a client that's really polarized in their position, the best explanation that I can give to them is that even the president has speechwriters. So, certainly the story should be theirs, but sometimes it's appropriate to tone down some of the rhetoric and to really think about how is this going to affect the potential outcome of my case. Think about this. How many folks in here, in doing an initial consultation with a prospective client, has seen a client walk in the door carrying a banker's box or two of scattered paper? And you think to yourself, oh boy, here we go. Well, put yourself in the evaluator's shoe. If the evaluator has a custody evaluation expert, if the evaluator has a custody evaluation client coming in the door, and they're bringing in 3-4 boxes of scattered paper, they're going to think this person's nuts. Case resolved. So really as an attorney, what you can do is you can work with the client in obtaining any emails, any documents, any corollary data that's going to help advance your position. Edit it, organize it, highlight it, post it. These are the sorts of things that you and your staff can really do to make a very compelling and a very organized presentation to the evaluator during this process. The third area where I see a lot of the responding psychologists, that they indicated that there were areas of needed improvement, which I think is really important, is the thought process of the litigant entering the evaluation process. Many litigants enter into child custody litigation thinking that all that the evaluator wants to see and wants to hear and needs to see and needs to hear are the sins of the other party. And they really don't give any thought as to, well, what am I bringing to the table as a parent? What are my parental skills? And so working with your clients to articulate their strengths as a parent and how those strengths could translate into custody or shared time with their children is a really important component of your advocacy. A fatal flaw that I think many litigants enter into in this process is the inability to objectively identify any strengths of the other parent or show a willingness to work with the other parent despite their differences in their marriage relationship. I'm not sure what your experience is, but my experience has always been that the litigants who, despite the fact that they're getting divorced, at least can voice a desire to co-parent and voice a desire to work with this person, that's going to go a long way. And so even if your client truly doesn't feel that way, give the lip service of it. At least say the right words to the evaluator. And if you're not going to do that, how could you ever expect to receive joint legal custody or shared parenting time? It's a train wreck waiting to happen. So certainly sitting your client down, coaching them as to what it is that's coming out of their mouth is going to be very important. How else can you help prepare the client? Well, people are judged by their appearance. It happens. And I don't care if the client is white collar, blue collar, or no collar. They absolutely need to be told how to dress for this process and how to act. And so, my recommendation to a client would be that you don't go in your suit because you're going to have to be down playing with your kids, and that's not going to be comfortable for you. If you don't wear a suit every day, you're going to be stiff, and you're not going to feel free to open up and deal with evaluators. So what I recommend is that you wear casual but conservative clothing to the evaluator's office. Another topic, it may seem like a no-brainer, but tell the client if there's ever going to be a time that you're on time, it's the day of your evaluation. Don't show up 30 minutes late. Don't no call, no show. A missed appointment or showing up late can feed into all sorts of assumptions from being lazy or unorganized or suggestions of substance abuse or all other variety of negative perceptions that you don't want to have from the start of your evaluation process. I always advise my clients that the evaluation, it starts the moment they walk in the door. So greet the receptionist cordially. If the evaluator is running late, you wouldn't do this in court, so you don't go up and ask the receptionist, hey, where is this guy? I'm ready to get this show started. I got things to do. You absolutely don't want to pick that impression. Since your client is going to be typically observed interacting with their children, well, some common sense things would be, how do you prevent a meltdown? I've got little ones at home, and I know if I don't bring my raisins, my sippy cup, and my diapers, I'm going to be in for a disaster and a meltdown of some sort anytime I'm out. So you don't want to have a meltdown halfway through your evaluation. Understand that there is likely going to be some form of cooperative play activity between your client and the children. And so don't let the evaluation be the first time that your client has played a board game with their children or the first time in 6 months that they have. Let them know these are the sorts of things that you're going to be doing with your kids in front of this evaluator, and the evaluator is going to draw a lot of inferences from how you interact with one another. So if you've not read a book to your kid, probably now's the time to start doing so. There are a lot of resources online as to what are cooperative play activities, and certainly I always encourage my clients, I'll give them a list of these are the sorts of games that an evaluator will want to have you and your kids engage in as part of the evaluation process. So certainly educating the client, having them be familiar with how that process would work, again, critical part of this process. You may want to coach your clients as to how they may choose to respond to questions by the evaluator, and make sure that they're clear that they're being evaluated not only as to what they respond, but how they respond. And so one tool that I use when I work with clients going through this process is to have them provide a list of the 5 to 10 worst things that the other side's going to say about them. And the more harshly that client responds to criticism, the more frequently I'm going to go through that exercise. Because what we're trying to provide is, put yourself again in the evaluator's perspective. They're very often an evaluator is going to want to put your client in a high-stress situation just to see how does this person, do they erupt in a ball of fury, or are they calm, cool, and collected? I think that the point of that exercise is how are they going to handle themselves in a corollary type of event. In a parenting time exchange, where things are heated. And so prepare your client for the fact that they're going to be asked difficult questions, sometimes ridiculous questions from their perspective. That's a part of the process to evaluate how they react. You should certainly coach your clients to be able to articulate and have an intimate understanding of the children's teachers' names, their doctors' names, their medical history, their friends' names, their secret fears, their favorite methods of getting to sleep, and any other idiosyncratic information that is important to the child. Personal story. My wife is also an attorney. We got 2 little ones at home, 1 on the way. And I will tell you what, I will never divorce that woman, and hopefully she never divorces me. Because, well, not number 1, I love her, but number 2, I would absolutely lose in a custody fight. Because we're getting ready to take a vacation. Just this last week, my wife put together an 8-page detailed list of how do you get the mealtime processed? What are what fruits and vegetables do my kids like? What's the process for bedtime? Right down to ways to respond to extra cups of milk. And so having kind of that level of knowledge of your children and being able to articulate it, that is a critical component of success in this evaluation process. You should coach your clients that there are certain words that they really should not be using, and those are what are called absolutes. So starting a response with, I never did this, or I always does this, or she always does this, that really provides a negative connotation. Calling the other parent or his or her family members names, that really should be avoided because it can paint the picture of your client being the problem parent. Clients should be encouraged to leave their internet research at home. The psychologist doesn't want to hear about how your spouse is a borderline personality person. Let them do that diagnosis. That's what they're being paid to do. So take note. You should certainly, as a practitioner, take some time to familiarize yourself with some of the personality tests and IQ tests and psychological tests that are going to be involved in this process. We're not going to talk about those today. That could be a whole other hour of conversation. But having a working knowledge as to what these tests are, what to expect. I personally think that you're going to do more harm than good to try to coach your client on how to fake a personality test or how to fake an MMPI. To me, I think if you're not trained in psychology, that's just going to blow up in your face. But certainly, educating your client as to what to expect. Okay, you're going to have a multiple choice series of tests. You're going to look at a Rorschach ink blot. Educating your client as to why those tests are provided and what it is that the evaluator is trying to draw from that. That's a critical component of advocacy. Now, we discussed that custody evaluators will often ask for a list of collateral witnesses that each parent thinks that experts should interview. If the evaluator doesn't ask for a list of collateral witnesses, provide one anyway. If your client doesn't have any collateral witnesses, then it's probably time to think long and hard of, does it make sense for us to pursue this evaluation? When you're selecting out your collateral witnesses, my general rule of thumb is that family don't make great collateral witnesses. If that's all that your client has, then that's all that they have. But really, who would make a great collateral witness? Great examples would be daycare providers. Now, for infants and toddlers, that could be really the only third-party neutral that sees both parents in a parent capacity. That's not a relative. Teachers, coaches, tutors, doctors, religious teachers. Any witness other than family that has a vested interest in the outcome of the case. So that could be friends, neighbors, coworkers. They may not be the best witnesses, but their information may still be given to the evaluator or the parent coordinator. So as you can see, the attorney's job doesn't end when the evaluator is selected. The attorney can guide the client through the process and, when necessary, take steps to step in and avoid and smooth over any misgivings. I always ask clients to contact me between every phase of the evaluation process so that we can kind of powwow as to how we're going to readjust our strategy, what are we doing to prepare for the next event in the process, and certainly as a practice point of view, calendaring these events and following up with clients would be important. To talk briefly about, I think we're running a little short on time, talk briefly about involving therapists in domestic litigation cases. I included in the materials the AFCC guidelines for court-involved therapy. We're not going to go into them today because we're running a little long, but take a look at those. Long and short of it is, if your client has a previously existing relationship with that therapist before any court process was involved, there's a heightened level of review, and typically in that sort of process, you're going to see the therapist really put their foot down much more strongly as to the ability to release the records. Rule of thumb is most records are ultimately going to be released. But if we have any sort of court-ordered therapy in which the court's recommended that dad go get anger counseling or that mom sees a psychologist, there's really no argument that those records aren't going to be admissible at some point in time. I'm going to hand it back over to Melinda to talk about preparing yourself and your client for the appraisal expert.
When it comes to valuations of property, what are some different types of way to value your property? Any suggestions? Okay. Anything other than an appraisal? Okay. There you go. Great. All great answers. So what is it that your client is going to benefit the most from? Early on in the case, I like to involve an appraiser, but I talk with my appraiser about just doing a more simplistic approach that doesn't cost as much at the beginning to see where the case is actually leading. But I think that it's always key to make sure that the property is valued appropriately and not just giving a guesstimate on it, because you could really be shooting your client in the foot if you're just using something like an assessment value or what we call our auditor's value, where it just bases a value on the tax assessment. And so usually I'll get a desk review first. I'll talk with the client about it though. They may not want to pay for a desk review and then possibly an appraisal in the future. But a desk review will give you that value, and it's cheaper. Ours costs around $50, where our appraisals cost around $400 to $500. If I or if the case turns into something that's heavily litigated, I actually take it a step further and talk to the client and the appraiser about doing a relocation appraisal. These are probably the best appraisals that I've had for purposes of my home. When it comes to valuing property, what are the biggest assets in a divorce case, other than our home? I'm sorry, I didn't hear that. Pensions and retirement plans? Great. So when we're looking at hiring the appraisal and a business evaluator, just like the mediator, guardian ad litem, we're going to want our clients involved in picking out who they want to do this appraisal. So you're going to want your client to be able to talk not only to the appraiser, but also to any type of business evaluator that you get for a business or any assets that need identified in your case as well. So when you're talking about the appraisal for the home, what is it that your client needs to prepare for to either get the best value or a lower value if we want the home value lower? Any suggestions? We need to make sure that the appraiser knows if there's been any improvements made to the home. If there have been improvements made to the home, contact the contractor who made these improvements, see how much they were charged. It's unlikely that our clients are keeping these records, but the contractors usually keep records for a while that can assist in that. We also want our appraiser to know about any repairs that need to be done. I had a case recently where the basement flooded, so there was actually structural damage. And the other side had an appraisal done. The appraiser didn't know about it, and we actually won on that issue because they didn't take into consideration any adjustments that needed to be done for the value of the home. So our appraisal won out over that because we did our research. We made sure that our appraiser knew everything that was going on. If we could back up a slide, don't know an appraiser or you don't use one in your area, there is a website to go on where there's actually the appraisals listed for your area. Ever since the mortgage reform, it's become a little bit tighter on what the appraisals are allowed to do in the area that they're allowed to be in. I like to keep my appraisers, they need to know the market value and what's going on in the market in the area that they're going to do that appraisal for me. So I don't like them to go outside of the 60-mile radius for mine. So there is a website that you can go on to, the acs.gov, that's been prepared, and you can, if you know an appraiser's name, look at their credentials. If you don't know one and you're looking for one, you can go on there and find that. So ever since the mortgage reform, the practices, again, they've really been adjusted a lot. We also need to make sure that we know what we want to do with that appraisal. Is the appraisal for purposes of possibly selling the house and splitting the equity? Is the appraisal there to determine what the actual value is? And we also need to consider whether or not there's a premarital interest in the home. So if there's a premarital interest in the home, what else do we need to do? We need to determine what the value was at the time of the marriage. Going back to the business evaluations. Sorry, Jason. When we have pulled some business evaluators to prepare for today, we have talked to them about what they want from our clients and what they expect and what we can do to best assist them in their process. One of the biggest things is not to wait until the last minute to get your business evaluation done. Our courts in Ohio actually put together a scheduling order that requires us to have our expert reports in at a certain point in time. We also want them to interview potential valuation firms. Usually, when you tell your client to go do this, you're wanting them, again, to develop a relationship with that business evaluator. Somebody that they can freely talk to and have a good relationship with. And usually these initial consultations are free. And we also want to make sure that our client, again, understands the role of everybody involved, from themselves to the attorney to the evaluator. We want to make sure that when we develop these roles for each of us involved in the case, that we're not like double billing the client. If I'm preparing the spreadsheet, or is it going to be the business evaluator that prepares the spreadsheet? So if we're looking at determining the assets of the case, your home, let's talk about the home, the retirement, and any business. And the roles of the attorney, the appraiser, or excuse me, the business evaluator, and then the client. So what is the attorney's role? The attorney's role is there to strategize, do the legal arguments, and really be the quarterback for your case. The role of the forensic accountant or business evaluator should be looking at the financial issues involved in the case. And they should also be the one that's interacting with the other side's expert. Don't leave it up to the attorney to do that, because all we're going to do is go back to our expert, then to contact theirs. And our client's going to eventually get ticked off at us for increasing those fees up too high. And they also need to be that financial interpreter. Let your business evaluator do the interpretation for not only us, but our clients as well. That's what we hire them for. So they should be collecting, analyzing, and evaluating all of that financial information, and then interpret it in a way that we can all understand it and present it to the clients and possibly use it in any type of mediation or settlement conference with the court. The client's role is to provide that background information, history, the facts, and the evidence that the evaluator needs, as well as the attorney, to make sure that everything has been taken into consideration. When you are planning on getting the business evaluator, scope out everybody in the area. Is there an evaluator that has an expertise in one field compared to the other? Who do you think that your client's going to work well with? Some evaluators do visual graphs. Some of them just do written reports. I find that clients find it easier to understand something visual rather than reading a long document. They just get lost in it. So also set some clear communication up front so as not to surprise our client with those fees. Business evaluations are expensive. Attorney fees are expensive. So set out those realistic expectations from the beginning. Again, define who is doing what, such as preparing and maintaining that balance sheet. We don't want duplication of efforts, and we also don't want a duplicative spreadsheet. Again, back with what I said in mediation, what I like my business evaluator to do is, as they're looking through the financial documents, to make that column with exhibits, to make sure that we know everything. Another thing that a business evaluator can be useful for is they can prepare your request for production of documents or assist in that because they know exactly what documents they want to use in preparing their report or doing any type of tracing. Lastly, we need to make sure that our clients understand not to withhold information. Withholding information can compromise their own expert report, but also it can affect them in the case in the long run. There are some cases out there where the court has excluded a client's report and the testimony expert because they were uncooperative with producing documents. Their behavior is not going to be awarded by anybody. Your client needs to understand that. Just because they're stubborn and don't want to provide the information doesn't mean that the other side's not going to get it somehow or end up with a win just because your client wanted to be difficult. And relying on the other side's expert valuation is another thing that the court may do if they find that your client was being difficult. So usually if your client's prepared, they're not going to be the one that is shown as being difficult because they know from the beginning. So again, I think the key with third-party neutrals is making sure that our clients are prepared thoroughly. I think we have one last topic to present today. Jason's going to cover that.
All right, everyone, I think you're going to get off easy today because we're just about out of time. I was going to touch a little bit about vocational experts. Just kind of broad topic of vocational expert would be a third party that would make a lot more use in the realm of alimony or spousal support or reduced earning capacity. A lot of the same concepts would apply to a vocational expert that we've talked about today. You know, managing expectations, inform your client to know what to expect, what the potential expense could be, preparation and organization of documents. So they're the same sorts of concepts that we've already discussed that would apply in the realm of a vocational expert. So some keys to take away from our presentation today. Really three main keys. First and foremost, that the attorney's role doesn't stop at the time of selecting or subpoenaing the third party. Second is to educate your client as to what to expect with the processes. The expense, the time involved, and the management of expectations are critical components for representation. Third, never forget the mindset of your family law litigator. Think about Mikey from Swingers. Are they going to be making multiple phone calls to that third party? And what are you going to do to help mitigate that sort of behavior, those sort of self-defeating behaviors? So we have a few minutes left. Anybody have any questions before we take our 20-minute break?